right at about 2 weeks before the semester is over with. I think that in 2 weeks' time, you ought to be able to get the courtroom observations in, but because it's 2 weeks left, I mean, I also don't want to put an unnecessary time pressure on you. The other thing is I'm trying to think, like, how many of y'all have had have dealt with anything in the courtroom? Work related, or you having to go to court? Just messing with you. But I mean, I'm trying to weigh the value of that, especially for the points that I'm talking about. The points that are assigned to that, I'm not sure that it's worth making you rush around to get that done. Especially, like I said, the way if I had been able to teach the material on time, it would have been perfect, because I would have given you that assignment and we would have discussed it 2 or 3 weeks ago, and you would have had a full month and some change to do the observations. But that's my bad. We didn't get that done, so I don't think I'm gonna really hold y'all to it.
So are those points just gonna go away, or are you just gonna give us all A's?
I mean, it's easier for the purposes of grading to just give you the points and let it run through. I mean, so I think that works. So yeah, so that's the plan. That makes sense? All right, awesome. So, confessions and pretrial identification. What is a confession? And I guess what I'm really looking at is what's the difference between a confession and an admission? You will hear both of those terms used in the legal system. An admission is what it sounds like. It's admitting to some fact, or a statement that necessarily admits some fact. A confession, on the other hand, is a type of admission, but it's an admission that basically completes the proof of a crime. So let's play first 48. And of course, and I'm going to cover this in more full depth in just a minute, but of course, instead of adhering to the rights that people are read, they invariably talk to the police. Something about a guilty mind and a guilty soul that just has to confess, and they say confession is good for the soul, right? So they're going to talk to the police some kind of way, even if they don't mean to. And what the police want is a confession. So what the police want wants the suspect to put themselves at the scene of the crime, give up the motivation behind the crime, and an admission that they committed the conduct that led to the crime. So if you put all those things together, that's a full confession. That's what the police are looking for, a confession. They want the whole enchilada. Give us every piece of what happened. An admission by itself is maybe one of those pieces, or each of those pieces individually, but not the whole thing. So, you're in the murder case, you're sitting there in the room, and they ask you where you were on the night of the crime. And so, you're talking, and you shouldn't be talking to the police, but you're talking, and you tell them that you were at the IHOP, or the murder was committed at the IHOP. So, inadvertently, you've just made an admission. You have placed yourself at the scene of the crime. And if it just so happens that the time you were there was from 7 to 9, the murder was committed at 8, guess what? You have admitted to being there during the same time period as the crime. You know, if they asked you, you know, did you know the victim of the crime? Well, yeah, I know him. Don't like the SOB neither. Okay, well, so now you just admitted to a motive. You know, you don't like him. So all those things are admissions, but at the end of the day, you haven't confessed. Matter of fact, if they ask you straight out, did you kill him? You're going to say, hell no, I ain't kill him, right? So difference between admission and a confession is how full it is. And an admission is maybe just a statement that admits a certain set of facts. A confession is a set of facts that adds up to a whole crime. All right? So you'll hear, you know, things about admissions and confessions.
Okay, now what was the 3 components of the confession again?
I mean, I wouldn't necessarily itemize it like that. It's not the 3 components, but it is the confession is enough admissions to add up to everything you need for a crime. So it can be things like, and this is what I was talking about, it can be things like that you were at the same place and time as the crime, that you committed conduct that adds up to the crime, or that you admit to having a motivation to commit the crime. So it can be any one of those things or all of those things, but the confession is everything, those 3 things plus, you know, whatever else it takes for, you know, for a full appreciation of the crime. Sometimes the confession also includes, you know, an actual full acceptance of responsibility for the crime. Not simply that I'm admitting the different facts, but eventually, yeah, I did it. You know, period. I ain't mean to do it. Or, yeah, I killed him and I meant to kill that son of a bitch, he had it coming. I mean, you know, so all those things would add up to a confession. Confessions and admissions, to a certain degree, all of those things, if you make an admission or you confess, then you're incriminating yourself, and then you thereby implicate your Fifth Amendment rights. And the Fifth Amendment, no person shall be compelled in any criminal case to be a witness against himself. And again, it's fairly simple statement of what the Fifth Amendment is all about. That the government, and this is important, the government cannot compel you to make a statement that is against your interest in a criminal case. Just like all the amendments, we're talking about government action. Government action. So the police cannot compel you. The government cannot compel you to be a witness against yourself.
But also cover your spouse, right?
That gets into privileges. That's another piece to this. That's on the advanced end of it. And there are a number of privileges that have been recognized over the years beyond simply your spouse. So the book goes on to talk about, you know, who is actually protected against self-incrimination. And what does self-incrimination look like? Does the Fifth Amendment mean that you don't have to tell on somebody else? Nah. If I make all kinds of threatening, coercing statements to make you tell on somebody else, that's not the Fifth Amendment. I can't make you bear witness against yourself, but I can compel you to be a witness against somebody else, to the extent that that's possible. Another limitation about the protection against self-incrimination is that the protection only applies to truthful statements. Truthful statements. And when I say that, there's a long line of cases basically speaking to what they call the exculpatory no, which basically says that if a police officer has asked you a question and you lie, like, did you do this? Nope. That statement doesn't implicate the Fifth Amendment because it wasn't a truthful statement. And if ultimately it's proven that you did commit the crime or whatever else, that exculpatory no can't be excluded simply because it was a statement that was self-incriminating. It was a false statement. So false statements are not protected. A person who is going to assert their Fifth Amendment rights has to affirmatively assert their rights. Your rights are not necessarily given to you. You have to assert your rights. And so what I mean by that, we talked about Miranda earlier on, right? We talked about the two things that have to be present for Miranda to apply. And they were what?
Under arrest.
In custody
In custody and
and under questioning. All right? So the Miranda decision requires that police, when they have you in custody and are asking you questions, that they have to give you your Miranda rights. But what happens once the rights are read? Can you still talk to the police?
Yeah.
Sure you can. And can they still question you?
Yeah.
Sure they can. What's the magic phrase that it takes to cease the questioning?
You
I
want
want
an
a
attorney?
I want an attorney before any further question. You have to take that affirmative step to assert those rights. If you go to court, and so we've all seen the movies where, the person, Mr. Kimbrough, tell us where you were on the night of so-and-so when this murder occurred. I plead the fifth. Right? I plead the fifth. I'm not going to answer that question. You have to assert that right. They can ask it all day long, but you have to take positive steps in order to assert the Fifth Amendment. Now, when we won't get too deep into this because I think it goes beyond the course and scope of this class. But when you assert the Fifth Amendment in court, most of the time, you either have to assert the Fifth Amendment all the way or not at all. In court, it kind of works like out in the real world. If the police read you your Miranda rights and you keep talking to them, or if they read you your rights and you say, I want a lawyer, but then you start opening your mouth and running your trap again,
You waive it.
you have waived your Miranda rights, your right under the Fifth Amendment, because you kept talking. And it's the same way in court. If you plead the Fifth as to one question, but then want to try to answer the other question, you will waive your Fifth Amendment protection. So once you assert the Fifth Amendment, then you assert it as to everything. And that does get sometimes a little crazy, especially when people don't assert it for all of their testimony. And there are some trial tricks that prosecutors actually like for the theatrical value of it. I mean, even though a jury is instructed that a person's assertion of their Fifth Amendment rights is not to be considered in their deliberations, in a criminal context, okay, in a criminal context, your pleading the Fifth is not supposed to have any effect on how the jury makes their decisions. But if you started out answering questions and then all of a sudden you start pleading the Fifth, prosecutors like to push the limits and continue to ask you every question on their list because they want that jury to hear you plead the fifth over and over and over again. And very often, judges, whether they're asleep at the wheel or they're secretly in cahoots with the prosecutors, they will allow that to go on to a point where even if you argue it later on appeal that it was prejudicial, I mean, they allow the prosecution to continue to have you plead the fifth so that it creates that you can't unring the bell. The jury has heard you plead the fifth, and so no matter how much you tell them not to consider that in their deliberations, they gonna remember that. Well, you know, he asked him this, but he pled the fifth. You know, what you hiding? Because that's the way we think, right? If you plead the fifth, you are hiding something. Just like police officers sometimes tell people, why do you need a lawyer? If you didn't do anything wrong, what do you need a lawyer for?
My husband always asks me about that, because he always quizzes me about what
Yeah.
he's talking about in class. I said, well, you can ask for an attorney, because that's your right, whether you're guilty or innocent,
Sure.
what you did is right. And he was like, well, won't that, you make the police view you as being guilty? I'm like, yeah, but still, it's your right.
Right.
They can take it anyway.
And at the end of the day, the police. I had a conversation with one of my other students last night, and we were talking about a real world situation, and we were talking about asserting your rights. And in her particular situation, she has a personal situation going on where she's not under threat of prosecution, but police want to talk to her about a particular case. They want her to be a witness. But she doesn't want to be a witness, but they are pressuring her and like basically, you know, trying to coerce her to be a witness. And you know, and you know, for my 5 cents legal fee, you know, I told her, hey, look, you know, even if you were a defendant, you don't have to talk to the police at all. Period, freaking dot. And if they subpoena you to come to court, I mean, make them come get you. Make them actually physically come pick you up and give you a ride to the courthouse. Because, and they're going to have, you know, they're going to have a court order for that. They're going to have to stand up in court and convince the judge that all of that is necessary. And there's no law that requires you, you know, to be a witness in a case. I mean, you know, especially under the circumstances that she described. She's not the only person who could be a witness. And so, you know, asserting your rights is not, you know, the police officer's opinion doesn't count. The jury's opinion counts, and the judge's opinion counts. The judge knows better, and the jury, you know, if your lawyer is doing his job or her job, the jury should never be in a position to be prejudiced by your assertion of your rights. That's your job. I mean, any defense lawyer who sits there and allows the prosecution to keep asking you the question to have you plead the fifth is probably already thinking about appeal. I mean, because that's going to be appealable error. It's going to be appealable error on the judge's part because he allowed it to go on. But if I was a defense attorney and I had a sucky case, then yeah, I would allow that. Go ahead and do this because, first of all, I'm immediately going to ask for a mistrial. That's going to be my first thing. The judge is not going to grant me a mistrial. I'm going to renew my motion for a mistrial at the end of testimony and the end of the case, and then that is going to be my first ground of error on appeal. And it's probably going to be overturned on appeal, and I think, you know, most people know that. It's just sloppy. It's sloppy trial work, but prosecutors sometimes they go for the jugular and they'll commit that error. The only liability I bear as a defense attorney is whether or not my client will flip on me and file a malpractice claim. And I mean, you know, that usually doesn't happen, especially if they already know they're going to jail in the first place. I mean, and if I've explained to them that this is a matter of trial strategy, just play along. I mean, do what I've told you to do. I've told you assert your Fifth Amendment rights and don't say nothing when you get up there. Indeed, the other way that this comes about is every defendant has the right to testify in court. Is it smart? No. It is almost never advantageous to your case to testify. That's why you have a Fifth Amendment right, so you don't have to. They can't make you. But if you choose to do so, it almost never works out well. Almost never. And then you do wind up with the whole Fifth Amendment thing, because you had the bright idea that you wanted to testify and tell your story in the first place, and then when they start asking you the real questions, like I told you they were, now you don't want to talk no more. And again, you know, the prosecutor's going to go for the jugular. And the judge may think that it's funny and allow that to take place. And again, the only recourse I have at that point is ask for the mistrial, renew for the mistrial, and file an appeal on the backside. The right against self-incrimination can only be asserted in criminal proceedings, and generally criminal proceedings that are on the record. Criminal proceedings that are on the record. Now, you know, notwithstanding the fact that you have your Miranda rights, and your Miranda rights are rooted in the Fifth Amendment rights as well. So I mean, you know, obviously there are other ways that you can assert your rights. So, you know, Miranda is in the custodial setting. The Fifth Amendment umbrella just speaks to, you know, all the different types of hearings and proceedings whereby you can assert a Fifth Amendment right. So, if you generally, well, let me ask this question. So, can testimony be more than just your statements? Because let's think about what the Fifth Amendment says. The Fifth Amendment says no person can be compelled to be a witness against him or herself. So, is it just your statements, or can it be other things?
I mean, it could be evidence. That can be incriminating.
Evidence,
Action.
actions. No. Other witnesses, again, you know, the Fifth Amendment does not protect you from telling on somebody else or somebody telling on you. The Fifth Amendment only protects you from telling on yourself. And let's be clear about that, because I do believe you're going to see that again. The Fifth Amendment only protects you from telling on yourself. Any other combination of that, Fifth Amendment doesn't apply. And let's, you know, for the sake of clarity, once again, let's not get tripped up on privileges and things like that. Let's stick with pure Fifth Amendment. The Fifth Amendment only protects you from telling on yourself. Okay, that's it. Generally speaking, the Fifth Amendment does tend to only be limited to statements. And I just wanted to put that out there, because if you get caught up on the theory of the Fifth Amendment, then there are a lot of things that would tend to be, you know, out of the question. You know, we talked a little while back when we were talking about evidence and just types of evidence and what you needed a search warrant for. I mean, you know, fingernail scrapings, that would seem to be incriminating as hell, right?
Mm-hmm.
But because it's evidence, we don't even need a warrant, much less is there any Fifth Amendment protection to it. The gunpowder swab, incriminating as hell. If you got gunpowder on your hands and somebody was shot, that's very incriminating. Evanescent evidence. We're not gonna have a warrant requirement there, nor is that gonna be suppressible under a Fifth Amendment self-incrimination theory. Indeed, going back to my favorite topic that we blew a whole class period about 2 weeks ago, I mean, under the DUI thing, I mean, you know, even though the Georgia Supreme Court is tripping right now, your blood or breath samples under an implied consent are not being challenged because of their Fifth Amendment evidentiary value. It's the process and procedure under the Fourth Amendment that was the Georgia Supreme Court's basis for upsetting 30-some-odd years of law. Okay? So even though those things are incriminating and they come from you, Fifth Amendment is not going to protect those things. Generally speaking, the Fifth Amendment, at least under our jurisprudence, is about your statements. In some circumstances, you can see actions if the actions themselves are compelled by the government. If somebody sees you doing something, that's not going to be protected by the Fifth Amendment. But if police officers ask you to do something, to demonstrate, like, you know, here, read this statement, and the statement is the words that the bank robber used. You know, if you actually were to read that statement for purposes of some other witness to hear your voice speaking those words, that could be very well incriminating. Or if police officers asked you to stand up and hold a gun, I just want you to hold this gun, that could very well be incriminating. And I would expect a lawyer to challenge those acts requested by the government under a Fifth Amendment theory. Okay? But that's very rare. It's very rare.
So if they ask you to like be in a lineup, I guess.
We're gonna get to lineups
Okay.
later on. Because yes, they can request you to be in a lineup, but you do have some rights as it relates to not only having counsel present, but also you can't necessarily refuse to be in a lineup. Well, actually you can, but
It doesn't look good for you.
yeah, I mean, but if they have you in a lineup, you will have the right to counsel while you're in the lineup.
And they have to put people in the lineup who look similar to you, right? Well, they can't put you,
That's we getting ahead of ourselves. I don't want to talk about lineups right now. All right, so generally speaking, we've covered what the Fifth Amendment does and what is incriminating and how it works generally. So, just like with everything else, there's some exceptions to the rule. So what are some things, what kind of testimony can be compelled? Well, testimony that is being sought under immunity. If the government has immunized you from prosecution and from jeopardy, and there's that word again, jeopardy, right? So you are in jeopardy of losing your liberty. Once the government has taken that element away and they have immunized your testimony, then they can very well demand that you testify and testify truthfully. Okay? False testimony can lose your grant of immunity, right? It can void your grant of immunity. And a refusal to testify can also void your immunity. Immunity generally comes in two flavors, and one is use immunity, which means that whatever you say can't be used specifically against you. And so sometimes that's not a total immunity, it's just that whatever you've said can't be used against you, but they can certainly still prosecute you with anything else besides what you said. So that's how use immunity works. And then there's transactional immunity, and transactional immunity is the best from a defense perspective because transactional immunity is everything related to what you did. If a smart defendant is offered transactional immunity, they're going to tell everything because that's the quickest way for them to get clear on any possible crime they could be facing a charge for. Indeed, prosecutors don't like to give transactional immunity for that reason. Prosecutors are always more, yeah, I mean, they want use immunity. So they're more than happy to get you to tell on, place yourself in a particular piece of a crime so that that can have evidentiary value, as it relates to other people. And then they'll use those same other people to tell on you. I mean, so use immunity can still see you go to jail. Transactional immunity is, you're not going to jail at all for anything that you say, pretty much. I'm just talking off my head right now. Hey, but no, it's on 396 and 397. Use immunity is at the bottom of the page, and transactional immunity is at the top.
Oh, I'm all over here, 400.
See, that's what I'm saying. Y'all love jumping ahead. Y'all want to talk about everything but what I'm talking about. Now, your book talks about compelling information without immunity, but I don't think that they are accurate in how they phrase that. So they talk about circumstances where, just by rule or regulation, the government requires you to report the data. So like like the CTRs. Remember when we talked way back when we talked about if you move money $10,000 or more, you got to file a currency transaction report. I mean, can that currency transaction report wind up being an incriminating document? Sure it can. And were you forced to file it? Yeah, of course, the law says you have to. And so the book talks about that being a piece of compelled testimony without a grant of immunity. And I don't like that construction, and I don't like that way of putting things out there. So for the purposes of this class, the only way that the government can compel incriminating testimony from a person is going to be through a grant of immunity. Because to me, this whole thing of talking about regulatory information and stuff like that to me is like going back into the category of the pieces of evidence on your body, fingernail scrapings, fingerprints, DNA, all that stuff. I mean, and those are incriminating pieces of testimony that the government might be able to, they will be able to compel you to give. I don't like to mix those things up. So for the purposes of our class, compelled testimony is always going to be pursuant to a grant of immunity. All right? I mean, the book goes on to say exactly what I just said under letter G on page 398. When is evidence testimonial? I mean, all the time. And almost invariably, government is still going to be able to compel you to give up that evidence. Blood and urine samples, appearing in a lineup, wearing particular clothing in a lineup, which they can do. Giving writing or voice samples, which they can do. Being photographed or displaying your scars or tattoos. They will be able to do that. The issue is going to be, like I said, them making you do something beyond that. If the government wants you to walk across the stage, or if the government wants you to hold a gun, or if the government wants you to say a particular phrase, that's not going to work. And I would challenge those things. But giving a voice sample or giving a writing sample, yes. Providing your name, being photographed. Those are things that the government can compel you to do that may very well be testimonial in nature, but they're not going to implicate the Fifth Amendment. So, the book spends a lot of time next talking about Miranda, and I think, in my opinion, we've spent a lot of time on Miranda. I would encourage y'all to read the material more, but I think that y'all know what you need to know about Miranda. Just to kind of recap a little bit about some of the stuff, in custody. Remember, if you look at anything related to Miranda, you are going to always go back to the two conditions. So, was a person in custody? And the reason why we use the term in custody versus under arrest is that you can be in police custody without being arrested, right? Because what does arrest require? See if y'all remember this. What are the three things that have to occur simultaneously in order for a full arrest to exist?
That if you think you're being arrested, if the police intention at that point to arrest you and you are actually arrested.
Boom. That's a perfect answer. If you think you're arrested, the police intend to arrest you, and you are actually physically arrested. You can be in custody short of that happening, right? If you're at the police station and you don't think you can leave, are you in custody?
Yeah.
Yeah, you are. You are. And it is for the purposes of Miranda and for the Fifth Amendment, it is going to be your subjective feeling on the matter as to whether or not you were in custody. The full three-part test for the arrest is not going to apply. If you felt like you were in custody, if you felt like you could not leave, more likely than not, you're going to be considered in custody. Now, of course, on the other side of it for the police, I mean, if they're smart, if they're doing their job, they're going to do a lot of things to erase that notion in your mind. You may still feel like you're in custody, but they're going to do some things to offset that. Perfect example. All the confessions or all the interviews that I used to do that I did not intend for Miranda to be implicated, a number of things that I would do. I would sit the suspect near the door, as opposed to the way our interview rooms were set up. When you walked in the door, the police officer's seat was nearest the door, there was a table, and then the defendant was against the far wall. If I purposefully was trying to avoid Miranda, then I sat them near the door. And of course, immediately, my tactical friends will be like, now you've trapped yourself in this room and this guy can jump up and run out. Exactly. That's the point. He can jump up and walk out anytime he wants to because he is not in custody. Now, he ain't no fool. He's in the police station. He's not going to jump up and walk out this door. There's 50-11 police sitting outside this room. He's not going to jump up and walk out of here. But he's going to feel like he can, and I'm going to tell him. I'm going to tell him on tape, on camera, I'm going to tell him that, if at any point in time while we're having this conversation you feel uncomfortable with what we're talking about, just let me know. If you got to use the bathroom, it's right down the hallway, let me know. I'll give you a bathroom break. If you feel like stretching your legs, let me know. We get up, we walk out of here, go stretch our legs. I'm going to say all those things on tape because at the end of the day, whether he really felt like it or not, I have given objective evidence that he was free to leave at any time. We ain't got to do this. All right? In his mind, he is still in a police station. And he does not feel like he can get up and do those things. And he's going to testify to that. But my offsetting argument is going to be, no, I don't know why he felt that way. I told him, he was free to leave. Okay? Got to deal with that. The interrogation. Courts have interpreted any effort that you make to elicit testimony from a suspect as interrogation. So it does not specifically have to be a question. It can be driving a person by a specific location, knowing that their presence there could spark a spontaneous utterance. And by the way, that phrase, spontaneous utterance. A spontaneous utterance, by its very nature, is always going to be admissible, no matter what's going on. Spontaneous is the key word. If I'm trying to suppress a spontaneous utterance under a Fifth Amendment theory, I'm going to have to prove that the police deliberately set up a circumstance so as to provoke a spontaneous utterance. I'm going to have to prove that. But if I can, the Fifth Amendment is implicated. If the police officers are having a conversation around the suspect, and their conversation is designed to provoke a spontaneous utterance, that is going to be held to be an interrogation. I can't remember the name of the case, but it's one of the biggies. But basically, two police officers have got a guy suspected of murder. He's asserted Miranda. He doesn't want to answer any questions without a lawyer present. And well, there's two types of case, two examples of this. In one case, they get to having this conversation about it. Sure would be a shame. You know, we're trying to find this murder weapon. We wish you would be willing to talk to us. You know, it sure would be a shame if, you know, a little kid, you know, running around found this gun and killed themselves. You know, and they had that conversation amongst themselves. They didn't say anything to the prisoner, you know, hey, Joe, it sure would be sad if somebody found this gun and killed themselves with it, you know. And so then the guy says, all right, I'll take you to the gun. Interrogation. They didn't ask the guy a direct question, but their conversation was designed to provoke a response. As a matter of fact, the technical term of art is elicit a response. And the other one was two detectives having a conversation in front of a suspect in a murder, talking about the decency of giving the victim a burial. You know, it's a doggone shame. This girl, you know, will never find her body. You know, this dude is not talking to us, and we can't even give her family any closure and give her a decent burial. You know, what kind of Christian would allow that to happen? And you know, the guy, hey, look here. I'm not admitting to anything, but if you want to find her, she's in the field out behind the church. All right. Interrogation, yeah, that was still interrogation because their course of conduct was designed to elicit a response. And actually in the book, this is what's funny. In the book, this case is outdated. The book is outdated as it relates to this. The book is actually, I just happened to peep at it. The book is saying that in the case of Rhode Island versus Ennis, that the two officers' conversation was held not to be interrogation. That's wrong. I can't remember the name of the case, but the Supreme Court has flipped on that. It is interrogation, just like I've taught you. If you do anything that is designed to elicit a statement from a person in custody, that is interrogation. Okay? You cannot do anything that is designed to elicit a response from them. Once they have asserted their rights, then that's done. No further interrogation may be conducted. The book goes on to start talking about incomplete or delayed warning. The follow-on to what the book talks about a case that was decided in 2010 that talks about how accurate does the warning have to be? Does it have to be the same specific language that was articulated in the Miranda case? Supreme Court has never held that to be a magic formula. As a matter of fact, the Supreme Court has never established what the Miranda warnings were. The Supreme Court gave, back when Miranda was decided in '65, they gave some parameters and you know, what the law prohibits. But the Miranda warnings were made up from department to department. So there is no perfect form warning. And so the Supreme Court has recognized that there is no perfect form warning. So long as the warning adequately conveys to a person who's in custody facing questioning what their rights are, then we're all good. The court has come back since then, I want to say in 2011 or 2012, and said basically due to the proliferation of the Miranda rights on television, that everybody has heard the doggone Miranda rights somewhere, that really and truly police officers don't even have to recite the full Miranda warning. Because you know. And basically that's what they're saying. Everybody has seen on TV that you have a right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to have an attorney present before questioning. Everybody has heard that. People can say that off the top of their heads who have never been to police academy, never been to law school, nothing. And so what the most recent Supreme Court case says is so long as the police officers undertake some discussion with a suspect about their Miranda warnings. You know, you understand you got rights, right? You understand you got Miranda rights. Use them. That is sufficient to cover police conduct. Because on the other side, again, who bears the burden for actually asserting Miranda rights? I mean, reading Miranda rights doesn't do anything, right? It's up to the person to say, I want a lawyer and I don't want to talk to y'all anymore. So that's basically the way the Supreme Court has gone with that. It's not up to the police to give this full and satisfying explanation of your rights. Mere reference to it and mere, nodding of acceptance, yeah, I know my doggone rights, whatever. Sufficient. Because those warnings don't exist in the first place. I mean, they don't exist in a perfect form. And to the extent that the proliferation of media has basically put the Miranda rights out for everybody to see and know and have access to, police don't even have to read them to you. All right? They just have to reference them, and they do have to make sure that you understand you have rights. All right? As long as police officers have undertaken any kind of effort to make sure you know you have Miranda rights, that's it. They don't have to read them to you. They don't have to explain them to you. Nothing. All right? Technology is not good for everything. Get into all of these different things about different types of illegal confessions. Assertion, waiver, and subsequent interrogation. There's a lot of meat on these bones. Basically, this chapter or this part of the book is just talking about, like I said, it is the suspect's responsibility to assert the right. Once they assert the right, all questioning is supposed to stop. But if they start back talking, that is a waiver. And once they have waived the right, then everything is fair game. A suspect can waive the right on the front end, right? So let's say that you have a person in custody, you want to ask them a question, you can go ahead and read them Miranda. They can agree, after reading Miranda, or after hearing Miranda from you, they can agree to go ahead and talk. And that's going to be an effective waiver. If they later on decide to stop answering questions and assert their rights, they can still change their mind and waive. You can't induce them to waive, right? You can't go back to them and say anything. Soon as they assert Miranda, your contact with them is done, unless their lawyer does something different, and that's a whole nother piece of the waiver. So to the extent that, what does Miranda say? They have a right to have a lawyer present before any questioning. If they get the lawyer, and I guess we'll step into neatly a couple of things as it relates to that, but if they get the lawyer, and the lawyer says, I don't know, maybe you might want to talk to him, you can waive Miranda and go ahead and talk. If a person asserts their rights under Miranda, what do the police have to do in order to get their lawyer to them? Absolutely nothing. That's remember again, the person who has the rights has to assert those rights. Now, the whole thing about the I gotta get one phone call and all that other stuff, that's not real. There is no one phone call rule. Police cannot hold you incommunicado, which means they can't withhold from you the ability to contact the outside world, except under some very, very narrow exceptions and circumstances. I mean, clearly, if they're dealing with a situation where they feel like you might tip somebody off to evidence or to an impending law enforcement activity, yeah. If they feel like you're going to place somebody's life in danger, a witness, you're going to tamper with a witness or whatever, yeah. But there's going to be limits to that. And so, but for those limitations, you're going to have an opportunity to contact somebody in the outside world. And that's when you can get your lawyer. They don't have to call a lawyer for you, and they don't have to immediately get you access to calling your lawyer. You assert Miranda, they got to leave you alone, but they are more than free to leave you alone and leave you sitting in that room until it's time for them to take you over to the jail or wherever the next step is. They don't have to put a phone in there with you. They don't have to let you call a lawyer. Flip side of that. Let's just happen to say that as you were getting stuffed in the back seat of the car, hey man, call my mama and tell her get my lawyer. I'm going to be down at Clayton County Jail. If the lawyer shows up, do we have to let you know that he's out there? Nope. We don't. It's up to him to assert his rights and to keep his damn mouth shut. That's his job. It's not our job to run back and tell him, hey man, by the way, your lawyer is out here. Now, subject to, legitimate penological interest, are we going to allow him to see his lawyer? Sure we are. I mean, we're going to do that. I think maybe the way that I wanted y'all to hear that was, do we have to? And do we have to bust our behind to make sure that the lawyer gets to see him at the earliest absolute opportunity? No, that's not required. You do have to let him see his client at some point, let the suspect see his lawyer, but that's not an imperative. Police don't have to go out of their way about that. Let's see. not sure we talked about this. No, we did. How does the Fifth Amendment apply in a civil context? Can you plead the Fifth to a matter in civil court? Unless it relates to criminal conduct. Unless it relates to criminal conduct.
So that would be like where O.J. Simpson was acquitted on the criminal side and they went to the civil side on. He could have pled the Fifth in the civil side.
Indeed.
Okay.
The other piece to that is, let's say that you're in a civil case, but in the civil case, part of my lawsuit against you is you gave me faulty or defective equipment because you smoke marijuana all day long. And I asked you that question. I asked you, do you smoke marijuana? And were you smoking marijuana when you made my equipment? Because of course your admission in that civil case is on the record, right?
It can lead to a criminal.
And can it lead? Yeah, can it lead to criminal charges? Sure. If you admit to a crime in civil court, they can take that evidence and use it against you. Now, so let's say that you plead the Fifth in civil court. Remember how I said in a criminal context, if you plead the Fifth, the jury is not supposed to take any notice of you having pled the Fifth. You cannot be penalized for asserting your right under the Fifth Amendment in criminal court.
But in civil court, they consider.
In civil court, they can draw what is called, they can draw an adverse inference. And what that means is that in civil court, if you plead the Fifth, they can assume the worst. So if I ask you if you smoke marijuana in civil court and you say, I refuse to answer that question on the grounds that my answer might tend to incriminate me and I'm asserting my rights under the Fifth Amendment, the jury can be like, yeah, you smoke that shit. They are totally entitled to draw that inference, right? In a civil context, a lawyer is going to have to weigh the cost versus benefit to doing that. Because if you're admitting to something that the statute of limitations might have expired on, it might well be advantageous to you to go ahead and testify. Because you don't want the jury to be able to run wild with the adverse inference, right? So if the answer to that question is that, have you ever smoked marijuana or were you smoking marijuana when you made my equipment? If that was more than 2 years ago, and that could very well happen in a civil context, right? Because those cases drag out for years and years. It might be, instead of allowing their mind to run wild with you saying, I plead the Fifth, and they're like, oh man, they smoking dope. I have smoked marijuana. I don't smoke it often. I may have smoked some marijuana during the period of time we're talking about, but I'm almost positive I didn't smoke any marijuana the day that I was working on your project. So you've admitted to criminal conduct, but it's beyond the statute of limitations, and that worked out better for you than just pleading the Fifth. All right?
But you can't say that if you do still smoke, right? But you can't say, I don't anymore.
If they ask that question, the first thing that I'm going to do as a lawyer before you even answer that question is I'm going to challenge relevancy. Your Honor, what does it matter whether they smoke marijuana today? We're talking about something that happened 4 years ago related to this piece of property, related to this piece of equipment, and their liability is related to that. I don't see the relevance to current conduct as it relates to this, and hope that the judge agrees with me, because then if the judge doesn't agree and was like, well, no, I want to know, you might want to plead the Fifth on that one.
Yeah, because you can't lie.
Right, yeah, you can't lie. False testimony is not protected. All right? book talks about subsequent use of a suppressed statement for impeachment. Just generally, let's talk about impeachment. And in a criminal context or in a court context period, impeachment is not what you think when you think politically. Like, politically, you think impeachment, that's the process by which you remove the president or remove a judge or remove a congressman from office. Impeachment is just an attack on a person's credibility and character, right? So impeaching testimony is anything that casts doubt on the veracity of what's being said. So typically you will see not just suppressed statements under the Fifth Amendment, but any inadmissible evidence. You can see inadmissible evidence being used for impeachment purposes. Typically hearsay. So you may have a hearsay statement, and I'll give you a perfect hearsay statement, because hearsay, of course, is any out-of-court statement, right? Y'all all familiar with that from your other classes. Hearsay is any out-of-court statement, right? So it's not just how far removed it is, but any out-of-court statement is technically hearsay. So a perfect example of hearsay being used to impeach testimony is a written statement, right? So you dealing with the police, they love to get you to write a statement. Love to get you to do that. Why? It's the perfect impeachment tool. If for no other reason, even if you're not trying to lie, you leave stuff out when you write. The average person doesn't like to write more than 2 or 3 sentences. And they can talk to you for an hour and a half about what happened, and they're going to try to put all that shit in 3 sentences. I was chilling at my boy's house. This dude came over. They were shooting. I called the police and left. Whole statement. Whole statement right there. If for no other reason, that's going to be a good impeachment statement, because I'm going to ask you about all the stuff you left out. So, Reggie, you just sat up here and told this jury this wild and incredible tale about what my client had to do with this shooting that happened at your house the other night. And, I mean, it's an incredible story. It really, really is. And when I say that, I'm totally keeping it 100 with you. It's an incredible story. Because you just told them all of this. Didn't you talk to the police the night that this happened? Yeah. Didn't the police ask you to write a statement? Yeah. Gave you a pen, gave you plenty of paper, right? Sat you down in a room, gave you a Coca-Cola, right? They did all of that stuff. And what did you write? I wrote what happened. You see this piece of paper? I object, Your Honor. I'm not trying to get this admitted. Have a seat. Go ahead, counselor. You see this piece of paper? Yeah. What is that? That looked like the statement that I wrote for the police that night. What's that statement say? I was chilling in my boy's house. This dude came over. They got to shooting. I called 911 and I left. So, what really happened? Was in this statement or this big long ass story you just told to the jury? I don't want this statement admitted. All I want to do is trip him up and get him to admit that the first time he was given an opportunity to tell his story, it was 5 sentences long, as opposed to the story he's telling now. Classic impeachment. Not trying to get that statement admitted. I don't want that statement admitted. That statement doesn't do anything to help my case. But I do want to use it to show that this dude has told multiple versions of the story. Matter of fact, if he's written several different statements, I'm going to hand him every single one of them, and I'm going to point out all the differences between every one of them statements. And for each one of those, I'm going to, well, were you lying when you wrote that, or were you lying when you just told this jury this story? I'm going to ask him stuff like, didn't you talk to and I'm sorry y'all with the ethnic names, and I apologize for the bias that's inherent in that, but it just strikes my funny bone. So, don't you know Raquisha? Well, who is that? Oh, you gonna act like you don't know Raquisha now? Raquisha is your girl. Don't you talk to her every day? Wasn't Raquisha with you when all of this stuff went down? Didn't you tell Raquisha what really happened that night? Matter of fact, didn't you tell Raquisha that you knew they was gonna kill that boy when they got there? Notice I've not put Raquisha on the stand. Not gonna put her on the stand. But I'm gonna ask all of these questions, and everything I'm asking is classic hearsay, right? I'm talking about what she said. She ain't said now a word in court. Classic impeachment. Generally speaking, almost any inadmissible evidence can still be used for impeachment. Okay? The only exception to that rule is where a piece of evidence really has gone beyond just simply inadmissible evidence, and it's evidence that is stricken from the record. That's very rare, but there are some cases where a judge may find a piece of evidence so prejudicial or so illegally obtained that it's like shocking the conscience, and that evidence is not merely suppressed, it is stricken. It cannot be referenced by anybody for any reason. And generally speaking, if you violate that rule, if you do that, you're going to piss off the judge, and you, the attorney, are probably going to wind up downstairs. Let me see what Clayton County School System is talking about tonight. I apologize. Gotta love Clayton County. All right, so now moving from confessions to lineups. And this is fairly simple stuff to me. So there's actually three types of things that the book talks about, and let me clear up the differences between the three. A lineup is usually going to be a more formal and ceremonial thing where the defendant is going to be physically placed together with 5 or 6 other people and displayed to a witness. So the lineup is the old school, you go in the dark room, the lights are shining on the wall, 6 guys walk out there, and they say, turn around and face the room, number 1, number 2, number 3, so on and so forth. That's a lineup. A one-on-one show-up is a little different. The one-on-one show-up typically looks like this. A crime has occurred, police have a person in custody, they take a witness in the backseat of the car, ride over there to where the person is that the person? Yep, that's them. That's a one-on-one show-up. And then a photo identification is gonna be like a lineup, but with photographs. So that's where a detective is gonna put 6 photographs on a page and is gonna show that photo lineup to a witness and ask them to identify. In cop jargon, we tend to call the photo lineup or the photo array a 6-pack. Why? It's generally six pictures together. All right. If we had more time, there's a whole, we could just jump all off the deep end talking about what's messed up about eyewitness identification. We're almost to a point where I think really, logistically speaking, eyewitness identifications are probably gonna become outdated as real valid testimony. They may wind up being cumulative testimony, but nobody is gonna allow a case to rest upon an eyewitness identification. It's just, huh?
I would be except you.
You a mess. I mean, it's just everybody, human perception is so inconsistent. And even when people are trying to be objective, it's just time and time again, other evidence has exonerated people who were convicted based upon eyewitness identification. So with that said, even though we have to talk about lineups, one-on-one show-ups, and photo identification, the challenges to using those in a contemporary environment are already so great that you're going to start to see these things diminish. And I'll tell you, as we walk through the requirements for using lineups and one-on-one show-ups and photo identifications, not only have we relied upon people's frail and fragile memories, but you'll also see that the protections are not all that great. Generally speaking, at a lineup, you are going to have a right to counsel. But the right to counsel doesn't extend to preventing you from participating in the lineup. What counsel's role is at a lineup is actually rooted in the 6th Amendment versus the 5th Amendment, and it is simply based upon your right to confront your accusers. Because understand that at a lineup, you're going to have an accuser. Somebody is going to point at you and say, number 3, I'll never forget that, MF, long as I live. The lawyer's job is basically to be able to observe how the lineup was done, observe the witnesses' reactions, the witnesses' faults, and do you wear glasses, that sort of thing, and be able to attack those things at trial. But the lawyer can't stand up and be like, nope, he's not going to participate. The lawyer can't ask questions of the witness during the lineup. But you do have that right to counsel so that they can adequately help you confront your accuser when that lineup is introduced as evidence, okay? Because the way that's going to happen in court is they're going to say, remember back on January 15th, we all got together at police headquarters and we asked you to view a lineup. And during that lineup, 6 people walked out on the stage and they're going to go through that whole process and they're going to say, at the lineup, did you see anybody that you were familiar with? Yes. And who did you see? Well, I saw that SOB. Well, at the time of the lineup, how did you see him? He was number 3. And then they're gonna introduce into evidence not only that statement that just was made, but also, you know, we did conduct a lineup. The defendant was number 3. The victim picked out number 3. Okay? Do the same thing with a photographic array. Do you have a right to counsel at the photographic array? See on First 48 all the time, right? They go drive out to somebody's house, show them pictures. You see anybody on here that looks familiar to you? And they circle number 5. Yep, that's who did it. Right on there, how you know that person and from what, you know. This the dude shot my cousin. All right. Do you have a right to counsel at the one-on-one show-up?
No.
Nope. You don't. And logistically speaking, it's impossible for them to provide you with that right to counsel, and courts have basically deemed it an exigent circumstance. And because it's an exigent circumstance, and they have also balanced your rights to be accused with your right to be exonerated, frankly, the courts have said that a one-on-one show-up it cuts both ways. Not only can it be incriminating to you, but a person has an equal and equally likely chance that somebody will be brought by the police to that scene and say, no, that's not them. And then you can be released on scene and never be arrested and taken downtown and all that other stuff. And so one-on-one show-up does not implicate your right to confront your accusers. So now what does happen in terms of what are some things that have been used to bolster the six-pack? One of the ways that you used to be able to challenge a six-pack is on whether or not the police officer did anything to suggest one person in the lineup versus another. And this goes back to what you were asking me about earlier, that when a lineup or a six-pack is put together, everybody who is in that lineup and everybody who's in that photographic array has to be of generally similar characteristics. Height, weight, build, skin color, to the degree that it's possible, hairstyle. I mean, you can't put one dude with dreads in a six-pack and everybody else with short haircuts, especially when the doggone suspect is described as a person with dreads. I mean, you know, you can't do that. That automatically points itself to that person. In photographic arrays, I'll also say this before I move on to talking about photographic arrays. Lineups are very rare these days. They don't do many lineups. They don't do many, we're going to pull 6 dudes from jail and have you come down and sit on the other side of the glass. There's no real reason to do that anymore versus using a photographic array. They can even do a quote-unquote live virtual lineup where they put images on a screen. But you know, what's the difference between doing that and actually taking a photograph and coming to you with it? And so pretty much in contemporary usage, the photographic array is going to be the primary way that you're going to have a real full-up lineup. So the right to counsel is kind of almost out of the window, practically speaking, right? You don't have a right to counsel at a one-on-one show-up. You don't have a right to counsel for a photographic array. You don't have a right to counsel as it relates to just about anything because they don't do lineups anymore. Is that an erosion of our civil liberties in some ways? I don't know. Think that through. So the final ways that they are trying to bolster the efficiency and effectiveness of the photographic lineup and try to make it more fair and try to reduce that element of suggestiveness on behalf of the department or the detective who's working the case is now they're doing what they call double-blind lineups, or double-blind photographic array. Double-blind refers to these two things. That A, the photographic array is going to be composed by a detective that's not working on the case. A is going to be composed by a detective not working on the case. And B, the photographic array is going to be presented by a detective not working on the case. So in both of those ways, you've got two people who don't know anything about the case, who are going to both put together the array and present the array to the witness. I mean, because think about that. If you don't have a poker face, this is what the double blind is designed to avoid. You don't have a poker face. So you're presenting the photographic array to the witness. I want you to, the person doesn't have to be on this page. I just want you to take a look, and if you see anybody that looks familiar on this page, I want you to point them out to me. And then I hand it to you. And my suspect is number 2. And you point at number 5. And I'm like, shit. Well, now you know you picked the wrong person, right? And so now you're like, well, no. Wait a minute, number 2 could be him too. Did I suggest to you? Mm-hmm. Well, yeah, I did. Or if I'm like, I hand it to you and you're like, it was dark. I don't really know. I mean, come on. You sure you don't recognize anybody on this page? You positive you don't recognize anybody on this page? Nobody in the top row, maybe? You know what I'm saying? All suggestive. But if we're doing it double blind, first of all, under double blind, the person who puts the 6-pack together doesn't know who's going on this array. Matter of fact, we use a computer program, and the computers, generally speaking, you put in the parameters, the computer goes through the database, pulls 6 people out with those characteristics, and puts their pictures together. Obviously, the suspect has to be in that array, or is supposed to be in the array. That's the purpose for doing the doggone thing. I have very rarely seen, for veracity purposes, I've very rarely seen where we've presented a 6-pack to somebody and there wasn't a suspect in the 6-pack. I guess you could do that just for the purpose of record keeping to show that we have presented one and nobody picked anybody out of it. I've just never seen that. There's always a suspect in the 6-pack. That's the purpose for doing it. But if if that is just part of what's put into the system, and then your person who's pulling your 6-pack doesn't know who's what, they hand that 6-pack off to another detective who doesn't know who your suspect is. When they present that 6-pack, they legitimately, when they say, hey, look, the person may or may not be in here, and, we just want you to take a look and see if you can identify anybody that's in this page, they legitimately don't know. They don't know where the suspect is because they haven't been working the case. They don't know what the suspect looks like. They don't know anything about it. And so that's supposed to keep that element out of it. If you don't see nobody, you don't see nobody. I mean, they call back, hey, your witness didn't pick nobody out. Or your witness picked out number 6. Okay. Because you talking to the detective who didn't put the thing together, they shouldn't even know. It shouldn't even mean nothing to them. All right, well, tell me who number 6 is when you get back here. Right? So you want to introduce all of those different blinds, basically. You want to make it double blind. Holy gee whiz, Batman, that pretty much is all we need to talk about lineups, show-ups, and photographic arrays. let's take about 5 minutes, and then, and y'all may not even remember some of this, or I might not have taught it this way. What is the document that kicks off a prosecution? A warrant. Let's keep it simple and let's stick with a warrant. Because even if we went back and talked about a grand jury indictment, right? The indictment, and we did talk about an indictment. 23 people, they vote, the standard is probable cause. And if they vote to indict, they pass a true bill. If they vote not to indict, it's called a no bill. Even when they pass a true bill, you're still gonna have a warrant that actually commands the law enforcement of the community to go out and bring that ass here. So the warrant kicks off everything. The warrant is the command to go and get them and bring them. So that's where the fun begins. And I will tell you, just as a preface to talking about these procedures, I want you to always keep in mind, and this is something that I think maybe I said very, very early in class, but this is where the rubber meets the road. The one thing that if nothing else I want to be impressed upon you in this class is that no matter how much we're talking about these procedures and it gets a little dry and long-winded, we are talking about people's lives, and we're talking about people's liberty. And that's a very weighty thing, it's a very serious thing. You know, when you arrest a person and put them into the system, you are taking them out of their homes, their livelihoods, and so on and so forth. So for every piece of procedure, you know, those pieces of procedures are designed as safeguards against the abuse of that power. Okay? So all the stuff that we've talked about the Fourth Amendment, all the stuff we talked about the Fifth Amendment, that's all designed to make sure that common folk who have committed no crime don't have to live in fear of arbitrarily being deprived of their life and liberty, right? So that's the baseline of this. So when we start talking about some of these procedures that are going to be required, you know, after arrest but prior to trial, that's what we're looking at. We're looking at things that are gonna stand as roadblocks against an arbitrary prosecution. To get a warrant, we talked about having to go before a neutral and detached magistrate, right? To present your case under oath for a probable cause. Once you are arrested, you have to make an initial appearance before a neutral and detached magistrate, or a neutral and detached. Again, remember when the law says neutral and detached magistrate, they're not really specifying magistrate's court. They just mean a judge, a neutral judge. You have to be brought before a judge within 48 hours if arrested without a warrant, and within 72 hours if arrested on a warrant. That's what Georgia's law is.
72 with?
72 hours with a warrant,
Okay.
48 hours if arrested without a warrant.
Why is it different?
Because if you were arrested pursuant to a warrant, then there has already been a presentation to a neutral and detached magistrate of facts leading to probable cause. If you're arrested without a warrant, you've never seen the judge ain't heard nothing about it. It's simply the police officer's discretion that has led to your arrest. Most states in the modern era, in the modern world, you're gonna go to court way before 48 hours. If you're in any kind of modern area, there is no reason why a person can't be brought before a judge within 24 hours. Or there's no reason why they can't be brought within 24 hours. Because we have day court, night court, we have weekend court. I mean, there's always a judge somewhere where you can bring somebody before them for an initial appearance. First appearance is what we call it. Okay, the book says initial appearance. Here in Georgia, we call it first appearance. Now, you get outside of what I call the modern world though, and there are some places not that far from here that seem to wanna live outside the modern world, and they just hadn't been sued in federal court yet. That's what we're waiting on. As soon as they get sued in federal court, then they gonna get outside their comfort zone and they gonna start following the law. But it never ceased to amaze me that as recently as 2012, I was teaching a class to jailers throughout the state of Georgia, and a very significant portion of the people in that class were not aware that they had to make sure the person got before the judge within 48 hours. And the way the Supreme Court articulated it, that is 48 hours inclusive of weekends and holidays. So weekends and holidays, that don't give you no extra time. We're not talking about business days, we're talking about calendar days, right? So there were some places, and still are some places, that think that if you get locked up on Friday, it's okay for you to go to court on Monday. No, 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 no. If you get locked up on Friday, you better be trying, if the judge don't like working on Sundays, you better be trying to get the judge in there on Saturday. Alright? If you get arrested on Wednesday of Thanksgiving weekend, guess what? The judge has gotta work during the holidays. You cannot keep them from Wednesday to Monday. Indeed. Indeed. Price you pay for the bill. 24/365 business. But the Supreme Court, huh?
You woke me up for this.
Well, now you don't have to wake somebody up and all this other stuff. I mean, if you really think about it, 48 hours is a long time. I mean, and the more progressive agencies, I mean, like before I even knew anything about any of this, when I worked at Fulton County, our procedure was anybody you arrested today, they were gonna go to first appearance tomorrow at some point in time, and it based upon the time of arrest and booking, that set your court time for tomorrow. So you arrested a person, you booked them before 8 o'clock, they were gonna go to first appearance in the day calendar tomorrow. People who were arrested after 8 o'clock are gonna be in the night calendar tomorrow. So we never got outside of 24 hours. Never. And that was the way the system worked. I didn't understand it at that time, I understood it later. Okay, but Fulton County and Atlanta had been doing that for years. Your person is on the court calendar for the next day. And of course, Atlanta and Fulton County have been doing weekend court and night court for years. I mean, that's not a new thing for them. It's these smaller jurisdictions who don't hold court on the weekend, don't hold court at night, and until they get hemmed up and put on the news and have to spend out a whole bunch of money because somebody spent a weekend in jail and something bad happened to them, because that's the way it's gonna come out. It's not just simply gonna be that they waited more than 48 hours. It's gonna be they waited more than 48 hours for a judge, got beat to death in the jail, and then come to find out there really wasn't probable cause to hold them in the first place. And so now that jurisdiction is gonna write a check, a fairly substantial check. So, initial appearance, first appearance. What happens at first appearance?
Is there a probable cause to arrest?
No. Probable cause is gonna be at the preliminary hearing, and we're gonna talk about preliminary hearing in just a minute. Your first appearance is simply gonna be for a few things. Number one, the judge is going to read the charges that you're facing. Read the charges that you're facing. So you're gonna get adequate notice from the judge what you're charged with. Okay? That's the first thing.
Is that the one that usually happens in the jail?
Some of them happen in the jail, not everybody does it that way.
But that's the one that like Fulton County does it in the jail.
Yes, yeah, Fulton County does theirs. Matter of fact, actually, Fulton County Fulton County does a lot of their pretrial hearings in the jail, and we'll talk about a few more of the pretrial hearings, because it's not just first appearance, but yes, they do their first appearances in the jail. Clayton County does not, though. Clayton County brings theirs upstairs into the courtrooms, but that's because the Clayton County's justice facility is designed where the jail and the courthouse are connected. So moving inmates over to the courthouse for first appearance isn't a big deal. Fulton County, the jail is one place and the courthouse is somewhere else. So that's the reason why they created courtrooms at the jail to do that. The other thing, or the next basic thing that happens at first appearance is the judge is gonna advise you of your rights. Whatever rights you have at that time. They're gonna make sure that you understand that you have a right to remain silent and all that other good jazz. So even if the police have not advised you of your rights, typically the judge at first appearance is going to advise you of your rights at that point in time. In the modern era, as the Supreme Court has clarified the entitlement to an attorney for any person who faces jeopardy, any person who can be incarcerated is entitled to have counsel. The judge is also going to ask if you have an attorney, and if you're not represented by counsel, the judge is going to inquire into your indigency and initiate the process of getting you counsel. However that process works for your local jurisdiction. Usually the public defender's office has got somebody at first appearance strictly for intake purposes. And that's gonna be their job. Anybody that raises their hand, I ain't got no lawyer, I want one, go see the man over in the corner and start the process of the application and everything else, okay?
Fulton County had a lot there.
Sometimes at first appearance, the judge is gonna set an initial bail. And that is some jurisdictions separate bail from the first appearance. But typically speaking, first appearance is gonna be the first opportunity to have some examination of bail being set. Some bail is preset, depending on the charge. And so, in those cases where there are preset bonds, you won't see bail being addressed at first appearance, other than the judge may identify what the preset bail is. And that's like advising them of the charges. You're charged with this, your bail for that charge is this. It's not so much that the judge has gone through a determination of bail, as just having to advise the defendant what the bail is, what the bail amount is. Now, when we talk about bail and bond are the same thing. You'll hear bail bonds used in conjunction. They're kind of the same thing. I guess technically there is a difference. Bail is the concept of bail, and the bond is the actual physical document that secures bail. I guess you could be technical about that. But setting bail or setting bond, those two words, yeah, they kind of the same thing. The concept of bail is supposed to be just simply trying to have some security, some reassurance by way of money that the person is going to return to court. That's what bail is supposed to be. Bail is not supposed to be punishment. Indeed, when you look at the 8th Amendment prohibition against cruel and unusual punishment, the piece that we always skip is right after that. Nor excessive bail set. Alright? But does that preclude the $1 million bond? Or the $25 million bond that you know a person can't make? It doesn't preclude that, the way that you get around, or the way that we have gotten around the excessive bail as it relates to that, this, the bond that's so high that it can't be set, is there's two things. On the initial inquiry into how to set bail, Georgia has a statute, and most states do it the same way. They have a statute that lists all the different factors to be considered in setting bail. And it's everything from whether or not the person continues to pose a danger or a threat to the community, whether or not the person is a flight risk or has ties to the community, you name it. Those are the two primary ones that most people clearly jump onto, but I think there's actually 7 different factors in Georgia's statute. Can bail be denied? Absolutely. If you do pose such a great threat to the community that no amount of money really is adequate protection from society, then yeah, bail can be denied. I will tell you that if bail is so high that a person hasn't made bond within usually a period of about 90 days, in 90 days, counsel can ask for a bail hearing to look at a reduction of bond. And as much as the judge may hate it and as much as the prosecutor may oppose it, the judge is under pretty much a duty to reduce the bond so that it can be made. And again, we go back to looking at whether or not there are sufficient grounds to deny bond, or whether or not the judge is just not persuaded by the arguments that the defense makes in opposition to what the prosecution makes. I mean, if the person is a flight risk, you probably won't see a reduction in bond. If the person, doesn't have any ties to the community, no responsible people that vouch for them, no responsibilities to a family or children to support. I mean, if none of that stuff is present, then the judge just may not be moved to reduce bail. But that's usually gonna be if they haven't made bail in 90 days. Really briefly, let's talk about types of bail. The book has this a little bit jacked up, in my opinion. Let me talk to you about Georgia bail. Georgia bail bonds work in one of 3 ways. Cash bond, property bond, or commercial bail bond. Cash bond is what it sounds like. If you got a $50,000 bond, you got to put $50,000 on the table in order to get out. And it's never just the $50,000 bond. There's a whole list of statutory fees that can be added on to and collected with that bail. So a $50,000 bond is probably going to wind up being something like $55,000. One of the conditions of bond too, or not conditions, but how bond works is if you show up to court at the end of your case, then the person who posts the bond gets that money back. And I'll talk to you about how that's different with the different types of bond. So if you post a cash bond and you put up your $50,000 plus the fees, at the end of trial, you're going to get your $50,000 back. You're not going to get the fees. Some of them you will, but by and large, don't count on it. You will get your $50,000 bond amount back. The second way to make bond is a property bond. And what has to happen for a property bond is you have to use a piece of property that has enough equity to cover the amount of your bond.
And it can't be your property, right? Because that was the issue we faced with.
That's something that most sheriffs have added, is that they don't want it to be your property.
Because then you're still a flight risk. You can have my
Right.
house, I'm not coming back.
Yeah, and I don't agree with that, because you can put up your own $50,000. They don't have any problem with you putting up your own $50,000.
You can't put it on house.
So if I'll take your personal $50,000, I should take your personal property that has $50,000 of equity in it. And when I say $50,000 of equity, I mean, everybody in here understand how home ownership works, right? You have to be buying your home. You can't be renting it or whatever else. You have to have an ownership interest in it yourself. And then your ownership interest, the mortgage that you have outstanding on it, you have to have paid $50,000 of that in order to have $50,000 equity in your home. If you just bought your house, you don't have $50,000 of equity in your home. You just bought it. The bank owns your house, really. You paying the bank to get your house, okay? If you post property as a bond, basically there's a lien placed on the property during the period of time that it's encumbered as bond. Once you're done with trial, that lien is going to be released from your property. And then the third way that you post bond in Georgia is going to be by commercial bail bonds. Now here's the difference between commercial bail bonds and these two previous models that we talked about. Under a commercial bail bond model, the bail bondsman, through a previous licensing arrangement with the sheriff of that jurisdiction, has already put up a whole bunch of money as collateral. And usually the amount of collateral relates to the amount of liability that they're able to have people under bond for. So, like in Clayton County, a person who is going to enter into a bail bonding business in Clayton County has to put up $150,000 in cash in a CD in order to write up to the first, I think, million and a half of bail. So they can write bails on up to $1.5 million worth of people off of that $150,000 cash that they have posted. And if they want to write more, they're going to have to post more collateral. So in your $50,000 bail scenario, they're going to put up their $50,000 on your behalf. Now, what are they going to charge you?
10%.
Typically 10%. They don't have to charge 10%. There are some cutthroat bail bondsmen out there that will charge 6%, 8%. It's the competitive market. The limit, I want to say, is 13%. Okay? When you pay them that 10%, that's their fee. That is not bail. So when the case is over, you're not getting that back. You paid the bail bondsman for him to put up his money on your behalf. He ain't have to do it. He did it because you paid him. You paid him that 10%. So you're going to pay him $5,000 for the trouble of putting up his $50,000. Again, that's why bail bondsmen can charge different rates. Some of them, like I said, charge as low as 6%. Some of them charge as high as 13%. In very rare circumstances, a bail bondsman may not charge you anything. I will tell you, based upon my own information and belief, and I don't think that this is anything that was necessarily wrong, but I have asked a couple of bail bondsmen that I knew, based upon my relationship with them as the sheriff of this county, I've asked them to post a bond for somebody. I didn't threaten them or coerce them, but it was a favor. And it was in circumstances that I thought were appropriate. A friend of mine who was a law enforcement officer was arrested. And I asked a bail bondsman to post his bond, based upon the fact that not only do I know this person, but they're a law enforcement officer. And, they're not going anywhere. They have ties to the community, blah, 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 all that. And so the bail bondsman didn't charge anybody anything to do that. It's up to the bail bondsman. Some bail bondsmen also will take credit, as crazy as that sounds. They will do a credit check on a person and, will maybe even make them sign a promissory note or something like that but they will post bond for them off of that promissory note and their good credit, instead of demanding an upfront fee. All right? There is a fourth type of bail that does not occur here in Georgia, and it's called they're calling it in here. No, it's not in the book. It is an insurance bond, and the insurance bonds are basically policies of insurance that are basically used to post the bail bond. It's almost like the commercial bail bonding model, where the person who is like the insurance agent posts their money with the sheriff, and then you enter into an arrangement of fees that they would collect from you on behalf of their policy of insurance that they posted. Georgia sheriffs don't like the insurance bond because usually that's just injecting another party into the transaction, and that's the company that underwrites the insurance. And so if I were an insurance bail bondsman here in Georgia, and I was trying to use insurance policies as security for my bonds, I might use an underwriter from Connecticut. And so I have posted bond for my client using one of those policies. That jackass skipped town. The sheriff wants his money. If I refuse to pay it, he's got to go deal with an insurance company in Connecticut to try to get his money. No. So insurance bonds not allowed here in Georgia. Now the book talks about two other things that I don't think, this is where I think that they have it too. So personal recognizance, that is basically not having bond. Now in Georgia, we do release people on their own recognizance all the time, and we call it a signature bond. Believe it or not, when you get a traffic ticket, you're under a signature bond. I think what I mentioned to y'all before was that every traffic stop was an arrest, right? It's an arrest and release on the citation. Well, the reason why you can be released on the citation is there's a little paragraph that says you're displaying your license in lieu of bail, and then you are signing an acknowledgement that you received the copy of the charges. So that's why when people get smart and say crazy shit like, I'm not going to sign that ticket, you go into jail.
Okay.
And it's not that you go into jail because I'm mad at you and you either going to sign the ticket or go to jail, but technically that's what the law is. If you don't sign this ticket, you are not signing your bond, and I can't release you on this citation.
Get on bail.
Right. You are refusing to accept bail is what you're doing. And so now, since I can't release you on bail, I have already arrested you and charged you, so now I got to keep you. And I can't keep you in the backseat of my car, I'm going to take that ass to the jail. That's where we do that. Okay? So the simple way to, again, if you listen to what most police officers say, they're supposed to explain to you what signing means, and in addition to signing as your bail, it also is just saying, hey, look, this is acknowledgement that you got the ticket, that you understand that you have a court date, and that you promised to come to court.
Or pay it.
I never say anything about paying a ticket. If somebody asks me, can I pay, I will explain that there's information on the back of the ticket. You can call the court, you can go on the website, and you can look for yourself. I can give a shit whether you pay it or not. It's not my point.
I had a cop threaten me that if I went to court, that he would tell the court how fast I was really going. He's like, so I suggest you pay it.
That's bullshit.
I was like, okay.
I would have told him speaking to the mic. Say that again.
That's what he told me. If I took it to court, he was gonna tell the judge how fast.
You should have told him, yeah, that just all depends on what I tell him when I get there. I mean, I might tell him that you fondled my breast while we were on this traffic stop. I mean, do we really want to get into dueling bullshit and lies? I mean, I think I'm gonna win.
He called for backup.
Yeah.
I'm a 5'0" girl. He called for backup. There was 3 cop cars behind me.
Where were you at?
Palmetto.
Okay, that makes sense.
Where?
Palmetto.
thought you was a cricket trafficker. I mean, you know, shit, there ain't nothing down there but crickets and palmetto bugs, big flying roaches.
I had a bright yellow card. It's not like you could really miss me driving around town.
Like I said, they ain't doing nothing in Palmetto, so that's what that was all about.
They were bored.
I have a legitimate criminal violator of the traffic code. Your story is always good. What happened to you?
No, this was pretty calm. So, Tuesday, I got back from Vegas. In a parking lot, some lady.
This is already going
So
wrong.
you're talking about Vegas.
See,
sober.
you're not supposed to mention Vegas. That's remember what happens in Vegas stays in Vegas. You're not even allowed to refer to Vegas.
That's
You got back from out of town.
I got back from out of town. This
Period.
lady backs up into me. That's fine. Nobody's at fault. Blah, blah, blah. I completely forgot about my tag. So when she runs my plate, she was like, oh, your tag came back unregistered. I'm like, what are you talking about? And I was like, oh, shit. My birthday was Saturday. So
Yeah. It shouldn't be unregistered though. I mean, it would just be expired license plate.
that's what she said, but
Yeah.
whatever. So I went and got it, my new tag yesterday, and she told me to call the number and they can throw it out. I called them, they're telling me to come to court, and I'm like, that's not what the officer told me.
Yeah, I mean, you probably you dealing with a dumbass. And what I'm saying by that is that the old school way of doing that is that you are supposed to physically come to court and show that you have registered your vehicle. Now the reason why I say that's old school is because shit, they can go on the computer right now and see that you paid.
But nobody's gonna do that. That's too easy.
That'd be too much like right. That would save you some time and trouble. It's like the thing of this, and we still have officers that do this. And it's just being picky, and I just hate picky shit for the sake of picky shit. Come up to the window, I need to see your license and proof of insurance. Standard thing, license and proof of insurance. Well, here's the thing. Well, not only do you not have to have proof of insurance, but this is the thing. Even as it relates to license, right? If you don't have your license on you, and even though there is a doggone stupid charge in the book that says license not on person, the computer tells you whether or not the person is licensed, what their status is, and whether or not they have valid insurance. That is a part of the system. When I used to go up to the window, just out of habit, I did always ask for license and proof of insurance. But if they didn't have proof of insurance, I didn't get twisted. And if they didn't have their license, I just need you to give me your name and date of birth. Because all I need to know from you is who are you identifying yourself as? All right? Because that's all that's really germane to me. I mean, I'm not, again, talking about being picky and being a little Nazi. It really is not my job to identify you, right? I mean, like, that's not the thrust of my traffic stop. The thrust of my traffic stop is to cite you for the violation of the traffic code. The identification is simply a means to an end. And if you give me the name of the owner of the tag, right, it's all good. And that person, their license status and everything has already come back when I ran the tag. I mean, it's all interconnected. We know everything. So why be picky? Well, I'm going to write them for license not on person because they don't have their license with them, and I'm going to write them for no proof because they don't have the insurance card. Well, you can't write the citation for the no proof of insurance because that actually, the law does say that. You can't write a citation simply because they don't have the insurance card anymore.
Because when we were coming from the Barnes and Noble from South Lake, and actually we was in a car accident. Actually, the girl ran us out the road, and we were trying to get back on the road, and she still come over in our lane. And my husband didn't have the insurance card, but like you said, the cop knew that he had insurance on his car.
Yeah.
But still, he wrote him a citation for just not having the card, and he was like, well, I need the policy number.
The policy number is in the computer.
Okay.
It's all there.
They look it up at the tag.
The no proof of insurance in that case should have been thrown out.
I mean, we haven't been to court yet, and the guy said, well, you will get your court date in the mail, but we haven't gotten that yet. It took forever.
If that's the only citation that he wrote, probably the reason why you haven't gotten a court date is they already threw it out. Cause that's just totally not in the law anymore.
Yeah.
The whole asking for the card and you simply not having it, they ain't got shit to do with nothing anymore.
I mean, because even then, you know, from that.
Even so far as this, I'm not a traffic Nazi, and like I said, I hate picky shit. If I stop a car and their stuff comes back that their insurance is expired, the only way I will ask for cards is if you can show me old cards, but like showing a history. Because everybody's got them little doggone cards they throw in their dashboard, right? You show me that you have had,
insurance.
right, you have had Allstate for the last 8 years. I got 8 cards that are expired here. And the computer indeed does show that your insurance is Allstate, but it's expired. I am going to assume that that's between you and Allstate. And I ain't got shit to do with that. I don't know what's going on where Allstate has not filed your stuff or whatever, but you need to call Allstate and get that straightened out. I am not going to hook somebody up. Because honestly, if you don't have insurance on your vehicle, we're supposed to tow your stuff. You can't operate an uninsured vehicle on the roadway. So rather than me take your car, if you can show me all of that stuff, I'm going to let you ride. Because that's just, to me, that just makes sense. And certainly the same way, if you don't have the card, but the computer is telling me that you have insurance, I'm not going to take your car just because you don't have that card. Back in the old days, we did. In the old days before the system was set up that way, if you didn't have that insurance card, your car is going to the impound lot and you're going to tote the ticket.
You couldn't pull all that information out. It wasn't easily accessible to you like that.
Right.
So that was understandable.
I was in a wreck, a guy hit me, and I hadn't put my new insurance card in there yet, I had my expired one, and the cop was like, well, you need to make sure you put your new one in there, and blah, blah, blah. I mean, obviously, he pulled it up, saw that I had insurance, and then they're like, well, you have damage on your car, and there's silver paint on his car. Oh, okay, well, he hit me, so there's probably gonna be transfer of paint from my car to his car. They're trying to blame it on me, because it was like probably a 40-year-old guy, and then I'm, a 23-year-old female, trying to like
Yeah.
bully me. I mean, that's Peachtree City cops for you, all that going on. But he said something about, because it was an expired card, and it literally had just expired like a week prior to that. And he's like, oh, well, you need to make sure you put your new card in here, And then 2 more cops come up, can I see your insurance card? He has it, go look at him.
Yeah. Again, traffic Nazis.
Yes.
The 5th thing that your book talks about in terms of types of bail, that I don't think is a type of bail, but I guess I could be wrong in this, and this does also happen in Georgia, but Georgia doesn't treat this as bail, or as a separate type of bail. They actually will use this in conjunction with the other types of bail. And the book talks about supervised release. In Georgia, that is almost exclusively by way of ankle monitor. Alright? A judge will let you go home with an ankle monitor, either in lieu of paying money or sometimes in combination with paying money. Indeed, a lot of the bail bonding companies now also use an ankle monitor if particularly in those cases where I was telling you the person doesn't have the money but might have good credit, they're going to put an ankle monitor on them too. So, we're not going to take your money up front, but we will put this ankle monitor on you. I don't consider that supervised release. To me, that falls under the domain of the other types of bail bond, and the ankle monitor is just an additional tool used to improve one of those other models of bail. Also, the ankle monitor can be used if you you have special conditions of bail. And so sometimes a special condition of bond will be to, you know, not go anywhere near any of the witnesses, not go anywhere near the victim,
Be home at a certain hour.
be home at a certain hour, avoid contact with certain individuals. And certainly, the ankle monitor provides an enhanced mechanism for monitoring the special conditions of bond, because they can do all sorts of shit with an ankle monitor these days. I mean, they can make
They
it,
can talk to you.
they can make it talk to you, they can make it go off at a certain time, so for the curfew, they can draw a fence, an electric fence around you, where basically if you go outside of a certain, like, they can program it where you can go to work, they can program it where you can go to school, they can program it where you can go to your mama's house, but anywhere else,
Where does this fence come from? Your ankle?
no. I mean, when I say electronic fence,
Oh, yeah,
it's like, they're
It's like
pro-
a pole sheet.
Yeah.
they program, right, they program
Right.
GPS coordinates, and if you go anywhere other than where the GPS says you're supposed to be able to go, then it will go off and send a signal to them that you are violating. Yeah, it's not electric fence like the dog collar.
That would be funny though.
Yeah,
If you got shocked every time you left your house.
You probably wouldn't leave.
I wish we could do that to people, but at the same time, you know, I recognize the abuse behind that. And again, bail is not punishment, so.
Unusual.
You do that to your kids all the time.
And if
You left the
he
house?
goes like a certain, there's like a boundary around his house, like so many feet,
Mhm.
because he's supposed to be on house arrest, but he can go to work. But like if they go to lunch, he does construction, if they go to lunch, he can't eat inside the restaurant. He has to eat in the truck.
Right.
If he goes to the bathroom in the restaurant, it's gonna go off and be like, why are you in here?
Right.
And he has to answer them, I'm peeing, sorry, you know, like,
Yeah.
but it'll go off if he goes past that boundary and tell him he had so much time to get back in that boundary, or they're gonna send an alarm to, you know, the probation officer or whatever.
That's kind of sad
Wow.
though. That he can't eat with his coworkers.
The alternative is to sit in jail.
Yeah.
I mean,
It's so
and
sad
you,
though.
Yeah, you own bond. Be happy that you're not in jail.
But it's still.
That's kind of like the same thing with probation. I mean, yeah.
Oh.
Well, see now, and then that's even worse.
Yeah.
If you're on probation, you're supposed to be in prison. And people think that probation is like, I got away with it. I mean,
Mm.
you know, no, you're supposed to be in jail.
Probation.
All right, so-
officers make money.
In the book, they get into all this stuff talking about pretrial detention and conditions of confinement. I'm not really gonna fool with that. There is a duty to confirm the identity of a person who's in custody, and so the book talks about that. Just be clear that the jail does have a right and a duty to identify you. So, you know, all the fingerprint check-in and all this other stuff, I mean, the jail has that responsibility and the authority to do it. So, you know, when you play with the people in jail about who you really are, that's why they get bent and twisted. Because they do have that authority and they have the responsibility, because once they have a reason to believe that you're not the appropriate person to be in jail, they have a responsibility to release you. So that's something that y'all need to be familiar with. The other thing. So like I said, first appearance, they're gonna go through all of the initial steps. That has to be done within 48 hours, advise you of your rights, get you an attorney if you're indigent, set a bail, review a bail if they don't do it in a separate proceeding. 90 days after, they're gonna review bail. The book starts talking a whole bunch about what paralegals should do, and I don't want to bore y'all with that. I don't think that's germane at this point, even though that's what the class is about. The last thing that the book talks about, and it's really the only other type of normal pretrial hearing you're going to have, and that's the preliminary hearing. Preliminary hearing is like a mini trial, but the burden of proof is probable cause. So that's a very low standard. not much has to be presented at the preliminary hearing. Typically, at a preliminary hearing, you may not even see a prosecutor show up. You certainly don't have to have a defense attorney show up, and it can be very informal. But on the other end of the scale, some people can turn it into a literal mini trial.
Okay.
The defense attorney can appear with you at preliminary hearing. And so if the defense attorney shows up, and you have a right to counsel at that point, the defense attorney can ask whoever's going to appear on the state's behalf any questions and can adduce any testimony or evidence that he wants to get across at preliminary hearing. Because honestly, at that stage, if he can get the case thrown out, hey, then you go home. All right? Typically, if the state knows that defense attorneys are going to be at the preliminary hearing, then the state will try to get a prosecutor to be there. And indeed, in the more progressive jurisdictions, it is becoming more and more standard to have an on-duty prosecutor at preliminary hearing to present all the cases on the state's behalf and not leave that up to the police officer or somebody like that. Okay? Like I said, if there are lawyers on both sides, the preliminary hearing can turn into like a little mini trial. But again, probable cause is all that's at issue at preliminary hearing. Anything that you bring up in the preliminary hearing is on the record though, so you are bound by it, and that works both ways. And if a case is thrown out at the preliminary hearing, does that mean that the case is absolutely over and there's double jeopardy and you can never hear about it again?
No.
Nope. Routinely, we would see cases dismissed at the preliminary hearing stage for a number of reasons, whether the judge was pissed off or whether we just didn't present a good case, and you still have that case indicted. Also, do you have to go to a preliminary hearing?
No.
No. The defendant can waive the preliminary hearing. If there's nothing to be gained and if they're willing to concede that probable cause exists, then you can waive the preliminary hearing. Indeed, if you are not in custody, if you have made bail and you're out of jail, it's almost customary to waive the preliminary hearing. Because there is some legal precedent that if you have been released under whatever condition, that you're no longer entitled to a full and thorough sifting of the facts that led to your incarceration. You know, there's a legal theory that by going on bail, you are waiving the preliminary hearing by doing that. I don't necessarily like that, but it's allowable, and a lot of people do it. A lot of people do. They make bail, they waive their preliminary hearing. They're gonna come back at it at another point in time. I will tell you this: even if you don't waive the preliminary hearing, generally speaking, they're gonna give priority to jail cases for preliminary hearing. People who are in custody get first crack at preliminary hearing.
Because they're still trying to get out.
Well, because they're trying to get out, but also too, you know, the law favors, you know, if they're in custody and they're deprived of their liberty, then they need as much review of that case as possible. The last thing that we're going to talk about really briefly is extradition. And whenever you hear the word extradition, that is only between states or between foreign jurisdiction. It's not an extradition if you're going from Bibb County to Clayton County. And we've had a lot of confusion about that, even amongst law enforcement, because there is something that, if I put a warrant on the system, on GCIC, and when I put that warrant on the system, I'm basically authorizing everybody, I'm notifying everybody in the state that this warrant is out for this person, and for them to arrest them if they find them. We have had jurisdictions within the state of Georgia who stop somebody who have a GCIC hit. So like, let's say the city of Sandy Springs stops a person who has a Clayton County warrant. But the city of Sandy Springs feels like that's too far for them to travel. Or vice versa. Clayton County says, we're not coming up to Sandy Springs to get them. and then they say, well, you should have put on here that you don't want to extradite. It's not an extradition between Clayton County and Sandy Springs. And honestly, what we wound up having to get down to is that if you don't want to come pick them up wherever they may be found in Georgia, then don't put them on GCIC. And actually that runs afoul of GCIC law, which says you need to put them all on GCIC. So what we had to really do is just crack down and let people know, hey, I mean, it's your job to come get people, period, freaking dot. The judge has issued a warrant. The court expects you to bring them back. That is your responsibility. I don't care whether you're a little itty bitty city or you one of the biggest counties in the state. Gotta do it. Extradition is between states or between foreign jurisdictions. It is governed by statute between states and by a treaty between us and foreign governments. There is a process for extradition, but basically the threshold questions are, it really is just whether or not you have the person that is named in the original charging instrument. There's no burden of proof about the crime itself. It is whether or not this is the person. And so the only way you can challenge extradition is that that's not me. Okay? And of course, you know, in this modern day and time, that's not really happening. Right? If they knew who they were looking for in the first place, and they did that by fingerprint, DNA, something like that, then that's what they're going to introduce to prove that you're the person named in the extradition. And so that fingerprint or DNA is going to be conclusive, and you're going to be extradited. And all extradition is transferring you from the place where found to the appropriate court where your charges originate.
Does it have to be a crime in the place that you were found for them to extradite you? Like
No.
if you committed something over there that wasn't a crime here and you're a US citizen,
No.
okay, they still have to
No.
extradite you.
And that definitely, especially as it relates to foreign extradition, treaties between us and other governments, yeah, I mean, the treaty will specify those things, but the way those treaties are often worded, it is the sending, the receiving jurisdiction whose laws have been broken, and the sending jurisdiction has to respect and honor that. So if something is a crime in, say, France, but it's not a crime here, we catch the person here, and France wants them back, we are gonna send that ass back to France. Whether, you know, it may not be a crime here, but we're gonna send them back. I will tell you where you see the most disagreement with that, or the most violations of the treaties that exist, is about the death penalty.
Yeah.
And typically foreign jurisdictions are reluctant to honor their treaties and agreements with the United States because we do allow the death penalty. That don't bother us. We ship folks off to other countries all the time knowing that they're gonna be executed when they get there. But you know, right, it's not our problem. I mean, you know, most of the time if we're not gonna honor a treaty, we just gonna break the treaty, period. Like, we're just gonna sever all diplomatic ties. I mean, certainly, we are not sending people back to Iran, we're not sending people back to North Korea, we're not sending people back to people with whom we have no diplomatic relationships. Our refusal to have diplomatic relationships with them is basically denying the legitimacy of their government. We don't even talk to y'all. And so under that same theory, we're not gonna extradite somebody back to that country, no matter how much they demand it. Because most of the time, those people are gonna be political prisoners and that sort of thing. I mean, we have taken much bigger steps than just simply analyzing whether or not their conduct was criminal in their host jurisdiction. Extradition hearings usually take place right after the first appearance, okay? The book lists extradition last, but realistically speaking, if you're a person who is wanted from another jurisdiction, as a matter of fact, here in Georgia, you're not even gonna be booked under a separate charge. You're gonna be booked into jail practically as fugitive from another jurisdiction. And so your first appearance is gonna be related to your extradition. And then there will be a separate extradition hearing, and then you'll be, once again, either you will or won't be shipped off. The governor of each state will sign an extradition warrant, and they do that by a liaison office. The governor signs the warrant, but you know, you're not gonna go to the governor to get the warrant. You're gonna submit that information up to the governor's office. The governor's office has a staffer that brings all that stuff in a stack to the governor. He signs it. Once he signs the extradition order, you're on the way. All right? That is it. We